Okay, you filed due process pro se. Pro se is acting as your own attorney, which parents are allowed to do under this law. Um, okay, but you think you may have. Now I know it says screwed up, but it says screwed up, and I like that. I'm gonna start adopting that. I might make a T-shirt. Okay, do I have to list or address all topics I want to discuss in my complaint? No, not in the hearing. Okay, there's two aspects. You have your issues, but then you have other components that feed into your issues. All right, so it's more like a history or a timeline. And what it can be is it can be it's I mean that's what evidence is. It's just organized aspects of the history of the timeline, and all of those things tell a story that prove your issues. Okay, so in the video that you watched, what I said was that the hearing officer isn't going to necessarily render a decision in your favor if all that the parent is complaining about is going to be procedural violations, meaning that they didn't fill this paperwork out right, Your Honor, and they didn't have the occupational therapy therapist at my IEP meeting. And when those are procedural errors potentially. Even the big one of not having the proper number of people at your IEP meeting is it's a huge no-no, and it's a procedural violation. But the big question is, did it produce damage? And that's where the substance of the child's program is whether your child made tangible, measurable progress toward their goals. Did they make tangible, measurable progress? Because that's really what's at the meat of it. Now, why is that? Because judges need to be able to quantify damage. They need to be able to say, okay, your child did not progress, therefore they're entitled to this corrective action. If you just go in there and say, well, they didn't have the right number of people, Your Honor, at the meeting, and then the school district comes around when it's their time to present their case and they say, yeah, but look, Your Honor, the child made progress. Yeah, we admit it. We should have had somebody there. Sorry. See, the sorry now makes up for the mistake, because there was no quantifiable damage. The sorry was sufficient, but the judge can't sit there and give you a sorry. It just doesn't cut it. That's just a slap on the hand. So that's where in my video I was saying that you need to understand where the damage is in the substance of your child's program, the meat, the IEP itself. All right, and don't focus on the procedural stuff. Now, can you bring in the procedural stuff? Yes, of course you can, but you would do that through questioning. You would do that, like I said, in your preparation for hearing, making sure, like all of the emails, all of those things are relevant. But what you need to do is make sure that whatever your issues are, and it's just a series of sitting down and mapping it out. How are these emails and these procedural violations, how do they tie directly into proving this issue on the substance side? And so therefore, these procedural things are extremely relevant, but they feed into showing where the damage occurred. Now, the reason I said don't over focus on procedure, because too many parents will make the procedure the thing that they're trying to prove. Right. It's not what you're trying to do. You're trying to provide the history of the procedural violations and show how those feed into the substantive damage done, which are your issues. So your issues, for example, would be that the district failed to design an IEP for the 2018-19 school year. Throwing out an example, failed to design a IEP reasonably calculated to provide my child with a free and appropriate public education, during the 2018-19 school year. Okay, that's your issue. And then your evidence would be how, okay? And that can be all those procedural things, the emails, any of the communications. But just understand that some hearing officers are going to really want you to narrow the scope, and they may try to cut you off on some of this stuff. So that's where you just need to prioritize and understand who are the most important screw-ups, or where the most important screw-ups were. Was there any other aspects of this? Now, you got to exchange these emails, though, or anything that you have that you're going to be presenting. You need to make sure that you give a copy to the school system, even if you think that they have a copy. That's an evidentiary exchange, and even if it sounds redundant, I would still hand it all over to them, even if you got it from them, because you do need to come up with evidence books, and make sure that you catalog them, 1, 2, 3, 4, 5, and so forth and so on, so that when you're presenting them, that the hearing officer understands that this is this email. These 2 pages are going to be Petitioner's Exhibit 1, okay? And then this other block of, let's say, 3 pages that have other communications would be, let's say, Petitioner Exhibit 2. The IEP itself would be an exhibit. But just make sure that you understand and follow the procedure on exchanges, and who you're calling as witnesses. But I think you'll be fine. I mean, keep me updated. I'm proud of you. It takes a lot of guts to do that. It takes a lot of guts to do it. Okay.